Appeal number 6, People of the State of New York versus Casimiro Reyes.
May I request 2 minutes rebuttal, please?
How much time, sir?
2 minutes.
Yes, you may.
May it please the court, my name is Thomas Ross. I represent the appellant in this case. The evidence here was legally sufficient to prove that the defendant was part of an agreement that and shared the intent of his fellow co-conspirators in the gang that the arson on 57th Street.
So what is the concrete and unambiguous expression of his intent to commit a crime here?
Well, the evidence showed a sequence of events which targeted Wang Kwang. It lasted several days. It started with him retaliating over him just trying to leave the gang. And eventually, when he stabbed someone, then they were retaliating for that. It was a series of events, and the defendant was involved in
Well, the indictment doesn't charge him with a series, though. The indictment charges him with a specific arson on a specific date, right?
It charges him with conspiracy. He wasn't charged with the arson itself.
The conspiracy to commit that arson.
That's true. But the one event that is most telling is the fact that there was evidence he was participated in the attempted arson on the 18th Avenue apartment.
Right, but that's not what the evidence shows on this date. The evidence shows on this date that he was on his way to take revenge against another ring, Patrice's, I believe they were called. Isn't that correct?
That's true, but...
All right, so that being the case, then I guess it seemed that he may have been involved in a conspiracy to commit an assault, but I guess I find it a hard time to point in the record where you can say that there was an agreement by him to commit an arson or to participate or engage in an arson that's concrete and unambiguous.
Well, there's no one particular thing.
Well, how about this? I understand that because clearly there's a criminal conspiracy. People aren't signing a contract and agreeing to go out and commit a crime. We understand that. But you need to point in the record to a particular spot and say where it is, or say you argue that there are a series of 5 points, I believe, right?
Yes.
Okay. They all seem to involve presence, not agreement, except for the false confession. Would you agree with that?
Well, not just the false confession, but his earlier confession where he says, I'm a part of something, but I didn't do it. I mean, he's basically saying, I'm a part of this agreement, but I didn't do the
Or maybe he's saying I'm a
object
part of
crime."
the gang, but I didn't do it. And this is, remember, this is the police officer. This isn't his words. This is the police officer saying he said something like, I'm a part of it, but I didn't do it.
Well, the police officer was saying, I want to speak to an incident that happened the night before. And then the defendant eventually said, well, I was a part of something, but I didn't do it.
And in his written confession, isn't there a line about him not agreeing with what the head of the gang hoped would be the consequences of this attack?
It was not that he didn't agree, it's just
Well, at least
that
there's some ambiguity. I mean, you have language more than once that the man is saying, I don't agree.
it's not that he didn't agree, he just said he was sorry that it happened.
So let me ask this. If you don't have the confession, is your proof legally sufficient?
Yes, it's
Okay.
still,
So let's say the confession is taken out. You only have 4 points that you rely on. How so is your proof legally sufficient then?
well, first of all, you have to look in the context of the fact that he belongs to this gang. And there are just certain assumptions that don't need to be spoken of.
Are one of them that if you're part of a gang, then you essentially agree with anything that any members of that gang might do?
Under certain circumstances, that might well be. That's not what we have here. We have, like I say, we have more. But just the membership of the gang. It was explained that, you know, if that you agree to follow the orders of the crown. That's just understood. It's also understood.
But then, if that's true, is there any indication that he was ordered to do this?
Not the 57th Street. He wasn't ordered to do that.
Well, that's the one we're talking about, though.
But his presence at the Prospect Park meeting just was not superfluous. There was a purpose to that presence.
So is everyone who was present at that meeting part of the 57th Street arson conspiracy?
Yes, everyone was charged with that conspiracy. I mean, you don't have to...
Doesn't that contradict federal law?
No, well,
Well, I mean, not federal law, but federal case law.
No, because all you need to be convicted of a conspiracy is to be part of the agreement and then have an overt act in furtherance of that. That overt act doesn't have to be the crime itself. It doesn't have to be the attempt of the crime.
But what I'm having trouble seeing is where is the evidence of agreement beyond mere presence? Doesn't there have to be something, some verbal or other manifestation that you agree with what is being discussed?
Not under the circumstances here, because it's just understood that.
But generally, is that the rule?
Generally, not necessarily, because, yes, it's
Well,
better if
I
you
think
have an
part of the
overt
problem
say,
here
I
is-
agree.
Slow down a second. Part of the problem is perhaps we need to clarify what constitutes agreement in New York. There is a Second Circuit case that's been relied on, US v. Sabellos. Are you familiar with that?
Yes,
Okay, and some of the language there says that you need more than mere knowledge, approval, or acquiescence. There needs to be a need to make an affirmative attempt to further its purpose, the conspiracy's purpose. So if that was the New York standard, would you say that you met it in this instance?
in this instance, yes, because even though the 18th Avenue attacks that he took part in weren't part of the overt acts for the 57th Street, it still showed his intent, that he shared the intent of his
Do
co-conspirator.
you think there were two 18th Street attacks? Is that right?
Yes, it was somewhat ambiguous,
And you
but
think there's evidence that he participated in both of those directly? He was there for both of them?
yes, he confessed, and as part of his confession, he was part of a rock throwing, where they threw rocks and bottles.
The
and
first one, right, is
That was
the rock
first one.
throwing bottle.
And then there was evidence from Juan Burkett's statement at the pizzeria that was testified to by Jose Brand, that defendant was one of the 5 people who was in the group that threw 2 Molotov cocktails at the 18th Avenue apartment. So the fact that, he's willing to take part in this 18th Avenue,
He was acquitted of charges with regard to that event, wasn't he?
that was just for criminal mischief, yes.
So, counsel, let me ask you, given gang culture and the gang hierarchy with respect to this gang, but it seems to be similar to gang hierarchy, but anyway, respect to this gang, when would someone who's not part of that top branch, the decision-making branch of the gang, be a co-conspirator?
Well, under
When they attend a meeting, they don't speak, they're not asked a question. When do they, because of the membership in the gang, from the people's position, when are they co-conspirators in the actions of the gang?
when they.
If they are not the actor, right?
They're
If
not
someone
the-
else is the actor.
Right. When they find out about that this gang is going to commit the object crime, and they.
So how is that not, as Judge Fay has already pointed out, mere acquiescence, which isn't enough, at least in the Second Circuit?
Because, like I say, his presence at the Prospect Park meeting was not superfluous. If it was just some private thing from the Crowns would have done, they could have just gathered the 4 people they assigned to the mission and told them. But by having everybody in the gang there at the park, they could show that this is not just their private little thing. This is a whole gang. This is on behalf of the gang. This is something that we all agreed to.
Well, I had thought that the people that were ordered to do it were ordered to do it as a punishment for not having fulfilled their responsibilities to the gang membership, and the other members of the gang were not ordered or required to do that.
No, but that just shows that those who, even though it was punishment for them for neglecting their gang duties, they still went ahead and did it.
So if they showed up at this meeting, they had no idea what the meeting was going to be about, and all of a sudden, they're talking about some arson that they're going to do. The only way to avoid being a co-conspirator would be to say, raise your hand, say, I don't agree, or get up and leave. Is that?
Under these circumstances, yes, because it's just understood that when somebody in this gang is attacked, or someone just simply tries to leave, as Juan Kwong did, there's going to be retaliation against that person. they don't have to talk about that. That's just understood. That's part of the culture.
But it seems to me that the evidence in this case shows that this guy was a friend of his, that there was no indication that he would have wanted to. I mean, he actually went against the gang in some ways by not telling them certain things he knew about his friend and so on and so forth. So, you know,
But at the latest, by the time of the stabbing, the defendant had a choice. You know, either I'm loyal to my friend or I'm loyal to the gang. He chose loyalty to the gang. And furthermore,
Well, he stayed in the gang. How is that loyalty and agreement to this particular act?
well, the fact that he tried to commit the act itself just the night before by throwing Molotov cocktail and being part of the
Judge
group.
Garcia?
What's your evidence of his participation in the earlier attempted arson? What was the evidence at trial of that?
It was the statement that Juan Burkett made at the pizzeria that was testified to by Jose Brand. He said that that defendant was one of 5 people who threw Molotov cocktails, but that failed because they didn't break the windows. That was corroborated by Soraya's testimony that when he was going to the Prospect Park meeting, Desmond Blunt related to him the 18th Avenue arson, and Blunt told him that there were 5 people involved. He didn't mention the defendant. He couldn't remember who that 5th person was, but the 4 people that he did remember were the 4 people that Burkett had remembered. So, in a sense, Soraya's testimony corroborated Brand's testimony.
I see. And so, going back to something Judge Stein said on that conduct underlying that earlier attempt, it's somewhat confusing. One, I don't think the charging document is in this record that you provided. Is that right?
No, we didn't.
But it seems at some part in the transcript, that information about the earlier arson comes in only as background or as proof of this agreement. But as Judge Stein says, it seems that there's a criminal mischief and misdemeanor charge that actually charges that. So it seems inconsistent in the record to me.
Well, it was based largely on his statement there.
But was it charged or was it not charged? Because somewhere in the record, the prosecutor and the defense lawyer are arguing, and it's the defense lawyer for Mr. Reyes, about this coming in, and it's only coming in for this limited purpose. But it seems like it was actually also charged as a basis for criminal mischief count.
No, well, the criminal mischief, there were 2 separate attacks on the 18th Avenue. One was the attempted arson. The other was when the defendant confessed to throwing rocks and bottles. And
I see.
And there was evidence that there were 2. When Lawrence Trenise, the owner of the 18th Avenue, when he found...
So the criminal mischief count is based on the rocks and bottles and not on the attempted arson? Okay.
The attempted arson came in, and the judge charged the jury that was to be considered only to show that defendant and the co-defendants intent for the 57th Street arson and to reflect their agreement.
Understood.
Thank you, counsel.
Thank you.
Good morning, Your Honors. My name is Alan Fallick. I represent Respondent.
Counsel, why isn't membership in a gang, knowledge of the crime, presence at the, I think it's Prospect Park meeting, connection to the prior arson attempt at the 18th Avenue location, and the defendant's statements to the police, why isn't that enough to get us there?
That's not enough because none of that evidence, separate or apart, actually connects the respondent in this case to the agreement for which he is charged.
What would it take to connect him to that agreement, if not all of those disparate things?
You know, that's a difficult question. Actually, the control of the gang by the leaders is so all-controlling. They plan. They're the ones who select who's going to be part of it. Nobody's allowed to speak about it.
But they
And in
need
fact, they're
soldiers to
ultimately-
execute the plan, right?
They select who's going to, yeah, right, and they actually exclude all the others. So it's hard to even imagine what someone would have to do. They're almost precluded from being co-conspirators.
Let's say the defendant showed up at the Prospect Park meeting, which he did, and all the gang members put their names into a hat, understanding that whoever's name was drawn out was going to go commit the arson. Would that be sufficient?
If his name was among those?
If they.
If he was unfortunate enough to be selected, either
Well,
by
it's not
that...
a
I don't
question of
think
whether
that's what
selected.
he's
It's
asking.
It's whether he sat there while his name was put into a hat, knowing that if it's drawn, he was going to go commit this arson. Is that sufficient to show agreement?
I don't think so. The reason being that, yes, by being a member, he agrees to follow orders, so he would have to comply with that method, and he would have to ultimately comply with the order. And by
Is that because
unfortunately
you
being
think he could change
selected...
his mind?
Well,
Is that because you're saying even if he's picked, he could change his mind, or he put his name in so he didn't get beat that day, and maybe he won't get picked, and he's hoping for the odds to work in his favor? Is that the argument you're making?
No, my argument is that if he were selected, either by that means or deliberately selected, he would probably, unfortunately, like these participants who were selected, be forced at the risk of maybe just having to leave the gang or just getting up and facing the consequence for leaving. They'd be forced to commit the arson and thereby being involved in the planning, as these selected co-conspirators were at the pizzeria. They sat down, and unless
Loose
one of them got
understanding
up...
of forced, right? Because he has agency, he has volition, he can choose not to be in the gang, choose not to show up, choose to walk away. At his peril, I understand that, but nevertheless, he has some choice.
well,
So-
it seems to me, listen, being part of an organization, I'm part of the Catholic Church, part of the Democratic Party. I'm a part of the Ancient Order of Hibernians. I don't agree with every principle or every action that any of those groups take, and whether it's a criminal conspiracy or not. Being part of an organization merely can't be enough. I go to Mass. That doesn't mean I subscribe to everything that Pope Francis says. Presence isn't clearly enough. It would take an agreement with a specific act, and I think we should focus in a little bit on the 18th Street attack. I think that you need to focus in there because that seems to be let me finish. The people say that that this criminal mischief acquittal does not involve an attempted arson, only involves throwing of rocks and bottles. I thought that was all one event that took place simultaneously. Some people throw rocks and bottles, some people attempted to commit an arson. What do you say about it?
Apparently, based on respondent's statement, the videotape statement, some other gang members, he didn't include himself, went back as part of that mission, the same mission, and threw Molotov cocktails. So
On a different day?
It's not as clear. Yes, I think he said a day or two later, right.
So
I mean,
what is the acquittal on the criminal mischief charge?
Yeah,
An acquittal for?
Well, the acquittal on the mischief charge is sort of irrelevant in that the Molino, according to the court's Molino determination and its charge, it was the evidence of his purported involvement in the Molotov cocktail throwing that made that an arson. I would preface that by, our position is that the evidence is not reliable enough to show that he was actually involved in that, and that's even in a light most
Counsel,
favorable
I
to
guess
the
just to go to Judge Fahey's point and nail it down, there's some confusion in the record without the charging document whether the criminal mischief count included the earlier attempted arson. And it seems that the people's point is it did not. It was rocks and bottle throwing. And it seems from the transcript, there is argument by defense counsel and the prosecutor that the evidence of the earlier arson was only coming in to show agreement or other types of things. Do you agree with that or not?
I actually, the evidence is not clear enough. You're correct that the indictment actually, which doesn't charge appellant in that arson, that separate arson, actually charges that occurred on the same day that the evidence showed the rock throwing occurred, whether it's the same or not. But I just wanted to point out for Molino purposes that it was the arson, and we'll assume that appellant was involved. I mean, just assuming arguendo that he was involved. I think that the Molyneux evidence here, the evidence of those prior incidents, have become very clouded analytically. The Molyneux evidence was admitted for a particular purpose, only to show state of mind, that is, to infer a state of mind from respondents' involvement in this past crime, to show his state of mind with respect to his purported involvement in this agreement. So we're going way beyond the bounds of that Molyneux purpose when we start to argue that because he was involved in crime A, he was involved in
No,
crime B.
understood, but I think it seemed to me the purpose was to show the agreement later by showing he was involved in the earlier arson.
It was to show his state of mind with respect to an agreement,
Right.
which presumably was established by other evidence, not the Molyneux evidence. So in that regard, because our position is that there was no other evidence of his agreement, there was no evidence personally, as opposed to based on his association with the gang, personally involving him in any agreement with others, and with others is very important.
Let me go to the confession for a moment, right? We agree, I think everybody agrees he was not actually at the March 1st arson, right?
That's
So the
certain.
part of his confession is clearly false. But there are details in his confession that are true, right? That he clearly evidenced his knowledge of the plan. He knew when it was going to happen, he knew
That's
where it
true.
was going to happen, there are a variety of things like that. So, and then his confession as to his own participation is false, right?
Right.
So why doesn't the fact that he falsely confessed to a plan where he was not present itself provide evidence of his agreement?
Well, that he knew about these.
No, not that he knew about it. He could have said, I know about some details, but I wasn't there. But instead, he said, I was there. Why doesn't his falsely putting himself at the arson
I see.
provide evidence that he agreed?
It doesn't, because it's just so wildly speculative to say that it might provide evidence. There are so many other, I would say, speculative evidences that are much more plausible than that speculative conclusion.
But isn't this an appeal of a guilty verdict, so don't the people get any reasonable inference?
They certainly benefit from the deference that the sufficiency analysis affords, but even based on that evidence, the inferences that they draw have to be reasonable. Our position is that an inference like that, for instance, is just patently unreasonable.
What about his statement that he was part of something?
That too, as Judge Wilson pointed out, one, it's not necessarily what was said, it's what the police officer said he said. And he said something to that effect. And also, even in the context is not clear. He didn't say that in direct response to what were you doing, were you involved in this arson last night? Or the original question was, do you know something about this arson? The record is very clear that it was 3 or 4 minutes later in the course of that conversation when he says this. So we don't even know
I
what
thought
it is
it
that
was, he
triggered
said,
that
I was part of
response.
something, but I didn't do it. I thought that was the phrase that's...
Yeah, I mean, we're just talking, again, about wild speculation, but it's interesting that that particular statement, unlike the other statement, comes in for its truth. And we know what the truth is, that he was out looking for the betrayers at that time.
The more important point is whether or not a lie, a false confession, a lie can be evidence of an agreement.
The short answer is no. Possibly if the people had called an expert to describe how, but I would say that most people, from any objective standard, would not know what a voluntary, inculpatory statement really meant. I would guess that he had been led by the people, the police officers and the fire marshals, to provide more and more evidence. Possibly he felt that he'd be released afterwards. It's just not clear Or as we also speculate
But
in our brief.
isn't the real answer, it depends? It depends.
Yeah,
It depends on
certainly.
all the other circumstances
might
that
be
may
some-
otherwise confirm or corroborate that
Right.
indeed this
It
individual
depends,
agreed.
and whatever would be contingent, that would be contingent upon is certainly not present here. We really don't know what that possibly could mean. And as I said, with respect to, I was part of something, he was part of a mission to find these Patrias, that we know, and this evidence, this statement came in for its truth. So that's it's much more likely that that's what he meant. Ultimately, it's just wild speculation. It's not competent evidence of his agreement.
Thank you, counsel. Mr. Ross?
When he made his confessions, the police didn't know anything about this Patrias mission. They were asking about an incident, and they were asking about the arson.
Yeah,
So-
but the proof seems to be pretty consistent that by their own work, the fire marshal's work, they're looking at the videos. The guy wasn't telling the truth. The videos confirm that. So your argument is we want to say this part of his false confession proves a positive fact. These other parts that proves that he might have been with the Patrias committing some other act, we don't want you to count that on the conspiracy. You're asking us to parse it in a...
Well, we're not-
well, let me finish. As the key linchpin in establishing these other 4 points, and that's why I'm having the difficulty with it. Go ahead.
Okay, well, as far as the Patrias, it still shows that even though he found out about this arson mission, he wasn't so repulsed by the fact that this gang was going to do this.
But repulsion's not the standard for conspiracy.
I know it's not the standard, but it just shows everything all along the line. The fact that he's sitting there the night before, probably the night before, he's part of a group throwing Molotov cocktails at the 18th Avenue. There's just no need for the gang to ask him, well, do you agree to this 57? It's
Counsel,
just
you
understood.
didn't, the people didn't make an argument in this trial. It seems from reading the record that the Patrias incident comes up when the team that's going to go commit the arson goes out on the street after this meeting, and they see this rival gang, and they report it, and another team comes in to deal with the rival gang, including allegedly this defendant, right?
Yes.
Did the people ever argue that that mission itself was furthering the arson mission because there was a gang on the street that was interfering with their ability to accomplish that?
No, it wasn't charged as an overt act, and there was nothing that said it would interfere because the people who went on that mission weren't the ones who were on the arson mission, so it didn't really inhibit them.
So counsel, let me just clarify. Is the key point of your argument this participation, what you claim is his participation in an arson that is an attempted arson that looks very much like the arson that's then the basis for the conspiracy charge? So if that's your point, then let's try this hypothetical. Let's say he's ordered to go out and find the Patrias, and in the interim, they decide they're not going to use Molotov cocktails because that didn't work out so well the last time. They decide they're going to get back at him, JT, JK, whatever his name is, in a different way.
Mm-hmm.
Would his participation beforehand in an arson to get back at Huang make him now a conspirator in a different type of action? Because he
in
got
a-
the agreement to get back at Huang?
Not if he didn't wasn't aware of this different type of action. Now, if he had agreed to do the arson and there had been an overt act for that arson, say they went and bought the bottles of iced tea to use as Molotov cocktails, and then they changed their minds, he still would be guilty of the arson because he still agreed to that.
So if the agreement was merely, we're going to get Huang, without specifying how,
Yes.
could he be a conspirator? Regardless of the method that's used, if he's not a participant in the actual method that's used?
It depends on what you mean, how they're going to get Kwong, because here, the agreement was for a Class A felony be committed, which was second-degree arson. Now, if it was just how to get him, if it was just to beat him up, well, then it would be a lower level of conspiracy, because the object crime would be a lesser classification of crime. Just one thing about the charge, charge for the criminal mischief was on or about February 22nd through February 26th. So that clearly refers to the rock throwing, because the evidence showed that the 18th Avenue attempted arson most likely occurred on February 28th, which was the Saturday. And there was some evidence it might have occurred a day or two earlier. And then there was discussion about amending the indictment, because the rock throwing incident, there were various dates, and so we needed to amend the indictment, and there was discussion on that, and the court allowed that. So that had so definitely the mischief was about the rock throwing and not the 18th Avenue arson. But even though they acquitted on that, there was still evidence that showed that he was still, had this, shared the gang's antipathy towards Kwong. So basically what this case just comes down to is, do you always have to have an expressed agreement to be a member of a conspiracy, or can just the totality of the circumstances show that you implicitly agree? And I think when you look at his confessions, his participation, the nature of the gang, his presence at the meeting, like I say, which was not superfluous, and all of what it meant just to be a part of this gang, and his actions showing that he shared their intent, this was legally sufficient to show an implicit agreement. And I ask that you reverse the order of the appellate division and send it back to consider the rest of the claims. Thank you.
Thank you, counsel.